Hi, I'm Jason Sullivan of Rathbone Group, and this is on subrogation. This video discusses involuntary plaintiff actions, probably one of my most annoying and frustrating things that happens on a subrogation case. If you're a subrogation professional, you've paid out, you're seeking subrogation for your MedPay benefits, you've maybe filed arbitration, you're in contact with the other carrier, everything's going to be paid, everything's going well, and suddenly you get a complaint on your desk. It's your insured, and you've already ruled out there's no no UIM exposure. Why would you be named in this lawsuit? You read through the complaint and you realize there's no claim against your insurance company. They just want you to come into that litigation and preserve your own subrogation claim. But you already have it in arbitration. Well, you can't just ignore it, and you can't just let that litigation go by. You have to go in and look at the involuntary plaintiff claim and assert your right through that litigation. So why is this even possible, and how can they bring you in involuntarily? And it's under Rule 19 of most state and the federal rules of civil procedure. That deals with joinder of parties. The federal rule itself says that joinder of a party is required if, in that person's absence, the court cannot accord complete relief, or that person claims an interest relating to the subject of the action, and if the case is disposed without that person, it will impair or impede the person's ability to protect their interest, or leave an existing party subject to substantial risk or multiple and inconsistent rulings. So what does that really mean? It means that the court should have jurisdiction if there are multiple parties with either an interest in the action, or if the defendant is going to be subject to multiple claims against them from one single accident or one claim. If you look at it outside of the subrogation world, let's say there's a piece of property and someone wants to file an action to claim that they have superior rights to that. Well, if they just file against one person who may have a claim on that real property, and they don't name any of the other parties that may have a real claim to that property, then you're going to have one ruling as to party A versus party B, but it's not going to address party C, D, and E. Now, the federal rule isn't really all that clear that subrogation claims should be brought in and those insurance carriers should be brought in. But many states have expanded Rule 19 so that it is clear. Ohio is one of those states that really tracks the federal rule, but has an additional clause that says if a party has an interest as an assignor or assignee or subrogor or subrogee, that they can be joined in as a party to a lawsuit. Wisconsin has a similar rule, but it actually requires the plaintiff to bring in any known subrogated parties. In these cases, plaintiff's attorneys then rely on the rule to assert a claim that there is this insurance company that may have a subrogation claim, and therefore if they want to bring their claim, they need to do so in this litigation. It doesn't matter whether or not intercompany arbitration applies. It doesn't matter whether or not you're actively negotiating with the other carrier. It is imperative that that involuntary plaintiff complaint be answered and a claim against the tortfeasor asserted in that litigation. The big risk is if it's not asserted in that litigation, the state court judge is going to enter a default against your company. They're going to say, well, they didn't come and assert their claim, and therefore there is no claim. This would be true even if intercompany arbitration applied. And one of the reasons I say it can be frustrating is it's very difficult to sometimes get a state court judge who's familiar with the rules and procedures and the claims before them to understand the intercompany arbitration rules unless it's something they actively dealt with in their private practice or they've had cases come before them. But frequently they haven't, and so therefore they have a plaintiff saying, we asked them to come in and bring in their claim, and they didn't do it, so judge, please default them and rule there is no subrogation right, even though you're actively pursuing in another area. So anytime you get an involuntary plaintiff claim, it's important to take a look at it and then make sure that that is addressed in that litigation so that the claim is preserved. For On Subrogation and Rathbone Group, I'm Jason Sullivan, and that's the long and short of it.